I am pleased to be here this afternoon to give my views on the book Sexual Harassment and the Law. When I was contacted by one of the authors, Dr. Aina-Pelemo, to review this book, I agreed without any hesitation, as I saw this as another opportunity to continue my mentorship of this rising academic star. Adetutu is a bundle of talents, active, articulate, unassuming, deep in knowledge, and humility personified. I cannot do less. But to give her my encouragement in this regard. Our best is yet to come. As I envisaged, the book has further exposed the great minds of the two authors, navigating a very difficult terrain through their intellectual prowess and providing applicable remedies for the victims and a guide for the perpetrators. As we all know, the world today is challenged with the pandemic of sexual harassment in all its phases, especially in the world of work. It is an imperative that in a work environment, colleagues, both male and female, must relate, interact, and bond together in the larger interest of the work, as well as to enhance productivity. This necessity has been abused, taken advantage of, and even manipulated by some who are expected to lead the pack, either as principal, supervisor, superior officer, and in some circumstances as agents and contractors, taking benefit of their vantage position in the workplace. Being a global phenomenon, a lot has been said on this menace, but so much has still left untouched and unsaid on the complex nature of sexual harassment. Part of this gap is being filled by this book, focusing on the idea of sexual harassment and its implications, relationship, and effects on the practice of law in Nigeria. The book, written by the duo of Dr. Adetutu Deborah Aina-Pelemo and Dr. Paul Adele Ejembi, has 12 chapters, spanning 212 pages, detailing the various issues on sexual harassment and its implications. In this review, I do not intend to stand between you and the book by doing a chapter-by-chapter review of the book. Suffices to state unequivocally that it was well researched, with arguments adroitly articulated and very well presented. The title of the book, Sexual Harassment and the Law, is apt as it reflected the essence and goal of the work. It is a novel form of research in this part of the world and in this area of study, especially providing empirical basis from the perspectives of data. The work depicted the concept of sexual harassment through its introduction in chapter 1 by calling attention to various types of sexual harassment, where it occurs, and how it is carried out. The historical evolution of sexual harassment was the focus of his second chapter, detailing the way sexual harassment is perceived in Nigeria in comparison with other climes, especially the advanced economies. The work did a comparative analysis of the concept of sexual harassment from different countries using the developed and developing state index matrix. While this may not be a clear-cut comparison, It, however, provided a basis for the assessment. There appears to be a general notion of a mixture between sexual harassment, gender harassment, and violence against persons in the developed economy's perspective. The book also identified the lacuna in the existing legislative regimes in the developed countries, especially with regards to the issue of blurring of the clear meaning of, quote, unwelcome sexual advances in America, sexual nature in Canada, and acts of sexual nature in France. The book argued that the definitions need to be more explicit and more definitive for the protection of the victims. It was also discovered that the legislation did not provide for the third-party harassment under most laws in the developed countries. The definitions are as varied as there are countries, and the authors noted that, quote, having a uniform or exhaustive definition of sexual harassment is nigh impossible, unquote. The book recognized the diversity in cultural values in developed and developing economies on the issue of sexual harassment, noting that the developed economies consider sexual harassment from the gender identity's perspective, as against the males as the perpetrators against females in developing countries. Chapter 4 was devoted to sexual harassment in the Nigerian legal profession. One might ask why isolate the profession for analysis. The first thing that came to my mind was the fact that the authors belong to the profession, and secondly, the book has the goal of discussing sexual harassment and the law, and thus the natural starting place will be the profession. More importantly, the profession is expected to be the guardian of the society because law is social engineering. The question then is, if gold was? The authors themselves provided the rationale for the chapter because the profession is saddled with the responsibility of, quote, ensuring peace, order and security of the society at large, unquote. And it argued that if lawyers fail to speak for the society, who else will? The chapter therefore provided for the objectives, hypothesis, research methodology, theory deliberation, epistemological deliberations, and ontological deliberations of the study culminating in the book. From the statistics rolled out in the book, a lot has happened globally within the context of the profession that should command the need to put a satellite on the legal practitioners in Nigeria, especially when we do not generally have data like they have in other climes. The findings of the book demonstrated a great knowledge gap on the part of the legal practitioners interviewed with respect to the provisions of the Violence Against Persons Act and the powers of the National Industrial Court on curbing this pandemic. The book has breached that gap and further suggested that sexual harassment be made a professional misconduct. It is obvious from the perspective of the authors that the legal profession in Nigeria is seriously challenged by the menace of sexual harassment. Answering the question whether the respondents have experienced sexual harassment in the course of discharging their duties as lawyers, 48.7% answered in the affirmative. 63.5% confirmed awareness of sexual harassment in the legal profession, and a whopping 83.6% agreed that sexual harassment affects the growth of the profession. Curiously, the book used the word legal professionals more often than legal practitioners, maybe to emphasize the idea of professional outfit as against professionals as individuals. One of the key findings of the book is that there is no well-articulated sexual harassment policy in the legal profession, or indeed in the workplaces in Nigeria. To fill this gap, the book provided a model policy in the name of Queens and Kings solicitors and advocates. This policy was very well dated and comprehensively articulated to serve as a guide for law firms to fashion out their policy positions. This policy is not only good for law, but in it's also important for all other workplaces. It was clearly spelled out that this was just a model arrangement which could be adopted for use. It called attention to how conflicts on issue of sexual harassment can be resolved, how complaints are made, sanctions to be imposed, implementation of the sanctions, monitoring and evaluation of the sanctions, to mention but a few. The book also provided legislative and legal policy initiatives as well as model policy for the tracking and extermination of sexual harassment in workplaces, especially as it affects legal practitioners and the legal profession. It drew parallel from other jurisdictions, identifying the existing lacuna in such policies and initiatives and how our own can be better from the benefit of that insight. The book in chapter 11 provided detailed initiatives that could be undertaken by the legislature, the judiciary, the executive, the employers, the employees, the contractors, and the agents, the individuals and victims of sexual harassment in order to exterminate the pandemic for our workplaces. The book concluded in chapter 12 by providing an overview of the regulatory framework for gender-based violence using the international instruments as a guide, with both state and non-state actors playing critical roles. A review, especially of an academic one, that this one is incomplete by only pointing out what makes the book to stand out greatly without pointing out the shortcomings of the work. Getting the lapses in these books appears exceedingly a very difficult assignment, as obviously the authors were very painstaking in writing the book. However, as all human endeavors, perfection is an impossibility because it belongs to Almighty God. Thus, it is observed that the publishers did not pay much attention to the quality of packaging. Equally, gender harassment and sexual harassment are used interchangeably, but a critical examination of the two concepts will clearly depict connotation of differing natures of operations and approaches. It must, however, be acknowledged that generally gender harassment is usually confused with sexual harassment. On page 125, the book started using queens and kings solicitors and advocates, but did not give any explanation on how the name came about until page 126, thus putting the cart before the horse. In spite of these minor and insignificant omissions, the book is a masterpiece and a trailblazer in the area of analytical and empirical surgery of sexual harassment and the law. I cannot agree less with Professor Abiodun Alao of King's College, London, in his foreword to the book that, quote, this is one of the major contributions of the book and one that sets it apart from the casual writings that are neither rooted in theory nor deep in practice, unquote. It's a book that has fundamentally changed the face of this naughty concept globally and has widely opened the eyes of legal practitioners and other workers to the menace of sexual harassment in the workplace, as well as provided them with a way out of the menace. It has equally challenged the policymakers on how to navigate the conundrum called sexual harassment with the overall goal of changing society for the better. I recommend the book Sexual Harassment and the Law as a must-read for legal practitioners, academics, law firms, corporate entities, civil and public servants, academic institutions,